Good afternoon to all the dignitaries and attendees. The Moot Court Society, under the aegis of Law College Dehradun, faculty of Uttaranchal University, is back again with another insightful session. While we all are restricted to our homes, we, the Moot Court Society, have been putting in our best efforts to make the most out of this time by listening to the eminent people in the legal fraternity so that the never ending quest for knowledge keeps going. Today, in yet another event hosted by the Moot Court Society, I, Vanshika, and Aditi shall be the moderators for the day. After the success of our two national editions of lecture series on contemporary legal topics, our International Arbitration Week, and multiple guest lectures, we are here to welcome you to the international webinar to learn and discuss the topic Role of Administrative Judges in France. I would like to extend a very warm welcome on behalf of the Moot Court Society, Law College Dehradun, to our keynote speaker for the day, Judge Joëlle Adda, President UNDT, former Administrative Judge France, who is here to share her expertise and views on the same. I would also like to welcome Professor Dr. Rajesh Bahuguna, Dean, Law College Dehradun, Patron, Moot Court Society. Professor Dr. Poonam Rawat, HOD Law, Law College Dehradun, Chairperson, Moot Court Society, and the members of the Moot Court Society. This event would not have been possible without our attendees. Before we proceed further, I would like to invite our Honorable Dean, Professor Dr. Rajesh Bahuguna, for their introductory remarks.
Okay. Thank you. Thank you so much, Vansika. On the occasion of this international webinar on the topic of role of administrative judge in France, today's keynote speaker, Judge Joëlle Adda, who is president of UNDT and former admin judge in France, chairperson of Moot Court Society of Law College Dehradun, responsible for organizing this webinar, Professor Poonam Rawat, president of Moot Court Society, Ms. Anna Anupriya, its convener, Mr. Rahul Sharma, and today's moderator, Vansika Garg and Aditi Bansal. All the students from this university and different university of India and abroad. Also the faculty members, I can see they have joined to listen, Ms. Joëlle Adda. I take this privilege to extend my greeting to all of you. I welcome you on the behalf of Moot Court Society, Law College Dehradun. I welcome you on the behalf of entire Uttaranchal University family. I also welcome you from the land of God and Goddess Uttarakhand in India. You all are welcome on this occasion. Ladies and gentlemen, Moot Court Society of Law College Dehradun is one of the oldest society of the college, and they have been organizing, rather they have been inviting honorable judges of different Supreme Court, High Court and different countries. And in series of these talks, they have made us available interaction with the judges of different countries with different innovative new topics. And today, the topic is role of administrative judge in France. Ladies and gentlemen, we understand that in this world, there are two major legal families. one is common law family and other one is Roman law family. When we talk about common law family, it's Great Britain and the countries which either are or have been the colonies of Great Britain. India is one of them. And on the other hand, France and other continental countries, they are considered to be the Roman law families. So normally in our university and colleges, we are being taught about the system followed by the common law countries. Whether it is law or it is the judicial system or it is the functioning. So our students are always eager to know the real functions which is being followed on the other side. And that is why the today's topic has been selected by the Moot Court Society under the leadership of Professor Poonam Rawat ma'am. And for that we have with us today Judge Joëlle Adda ma'am. So I am asked to introduce you, madam. All right. So Judge Joëlle Adda is current president of UNDT and a full-time judge. She has been an administrative judge for over 20 years at the first instance and thereafter as appellate level. She served as president of the Administrative Court of Leave 2014 to 2017 and president of the 5th Chamber of Administrative Court of Appeal of Paris. She has also served as legal director at the Société du Grand Paquis and the French telecommunication and postal regulator. She has recently been visiting professor at the University of Iowa College of Law, USA, and a judge panel chair on France National Court of Asylum. Ms. Adda earlier worked as the legal service of European Commission from 2000 to 2002. She graduated from the University of Paris and the French National School of Administration, ENA. So with this, bienvenue à Law College Dehradun, Uttaranchal University, Moot Court Society. And I'm not taking much of the time. Merci beaucoup, madame.
Thank you. Thank you very much. I would like to thank you, Dean, Mr. Dean of the university, and I want to thank all the organizers of the Moot Court Society of the local College Dehradun, and the student who thanks to the student for attending this presentation. And it can seem strange at first glance for Indian students to take an interest in a subject like the role of administrative judges in France, which seems quite remote from the law they will have to exercise as a lawyer, judge, notary, or other profession they will exercise at the end of the studies. Because as you mentioned, there are these two systems, common law and civil law. But I hope that the issues I will raise in this presentation will show that the successes of administrative justice in France and in continental Europe, but also the criticisms that their action can raise, are in part common to many democracies around the world. I mentioned continental Europe because the French system that I am going to describe is more or less the same in Germany, Italy, Belgium, Luxembourg, Spain, and many other countries in Europe, and have in a large part inspired the judicial system of the Court of Justice of the European Union, at least before the United Kingdom joined the European Union, and now it's living, as you know, but this is another story. That said, I will focus on the French system of administrative justice and try to show how it works, its success, and the criticism it can raise. So I will try to share my, excuse me, I would like to share my screen with, can you see? Can you see the slides?
Yes, yes, it is visible. All right.
Thank you. Thank you. So this is the title of my presentation, and I would try to share the slide. So that's the main summary of my presentation. And now I will try to show the court structure in France. So as you know, even in common law, there could be chambers of a court specialized in administrative law, or judges specialized in administrative litigations. But in France and in continental Europe, it's a whole system of special administrative courts which exist besides the ordinary judiciary system. So on the left, you can see the ordinary courts. I will not go into details, of course, it's not the subject I have today, but so you see the criminal courts, the first civil court, the appellate court, and the supreme judiciary court, as we put it, which is the Cour de Cassation. But what interests me today is what you see on the right, which is the Tribunaux administrative tribunal of first instance, which their ruling can be appealed before the administrative court of appeal, and then there could be, in certain conditions, a final appeal before the Conseil d'État. So it's a whole, what we call jurisdictional order, because you see you have the three tiers system. And there are 42 administrative tribunals, so at this level, and 8 administrative court and 1 Conseil d'État. The Conseil d'État being the supreme administrative court in France, and which adjudicates final appeals. What we mean by final appeals, it's an appeal referred to the Conseil d'État to quash a court decision at last instance. A final appeal is not intended to judge the whole case again, but only a technicality or procedural defect or error of law committed by the judges in the lower court can justify a referral to the Supreme Court. But what I would like now to explain to you is all the kind of decision which can be challenged. Administrative judges have jurisdiction over disputes concerning public liberties, administrative police measures, taxes, public contract, civil service, public health, competition rules, environmental law, and urban and regional development. I will try to give some examples. So, you see the contestables administrative decision can be, I list a lot of them in this slide. there can be either individual or regulatory. This is very important. There are very few courts in the world, administrative court, which can even annul a regulation taken by the state or any public legal person. So what can be this contestable administrative decision? About individual administrative decision, it could be, for instance, for a migrant, the decision to refuse a residence permit as a student or as a worker or as a refugee. It could be the refusal to grant a building permit to a developer, or a notice of taxes can be contested by the taxpayer. It could be also the refusal of a promotion or of a bonus that a civil servant can contest. All these are what we call unfavorable individual administrative decisions. They are individual and they are unfavorable because the person, of course, suffer harm because of this decision. But people can also challenge, citizens can also challenge regulations, which means decisions that are anonymous and impersonal. For instance, they can challenge the urban zoning of a city, or a regulation imposing a certain local tax to certain category of businesses. What is an administrative police measure? This is very important because these are among the administrative decision which can be contested. An administrative police measure describes a rule taken by an administrative authority to limit the exercise of an individual freedom to protect public order. This notion of public order encompassing security, safety, peace, and health measures. For instance, for the moment, because of the COVID situation, the COVID pandemic, there are a lot of restrictions, including the lockdown, which explains that I am speaking for the moment from my apartment. So I will give an important example which just happened last week. Because of the COVID pandemic and based on the statutes which established the state of health emergency throughout the national territory, the government issued an order 2 weeks ago restricting the possibility of leaving one's home and in particular prohibiting gatherings, including in places of worship. So therefore, Catholic Association, faithful and members of the clergy have asked the administrative judge of the Council of State to suspend the provision of this order relating to the exercise of worship. So this is a good example of a police administrative measure. The applicants can be natural person, legal private entities like businesses or non-profit association or union, but they can also be legal persons governed by public law, like the representative of the state challenging a decision taken by a city or a region that he seems unlawful. I hope that I am clear. Of course, you will be able to ask questions if after I finish. So administrative judges are the guardian of the rule of law. They can rescind in some cases, and in some cases modify the decision taken by the administrative authorities. Only an administrative judge can do that. And under certain conditions, they can also order a public authority to pay compensation to a citizen who has suffered harm because of actions taken by the administrative authorities. I will try to give some examples. For instance, if a bar or a restaurant has been closed by administrative police measure, and this measure has been deemed illegal by the administrative judge, the owner of the bar or of the restaurant may be compensated for the loss of income due to this illegal closure. Also, a patient of a public hospital who has suffered harm because of a medical malpractice in this public hospital will be compensated by the public hospital because it will be considered as misconduct by the public hospital. So that's why administrative judges are the guardian of the rule of law. I can't go into details, but just remind you that the administrative courts interpret the applicant interest in seeking an annulment of administrative decision very liberally. So what is exactly the judicial review made by the administrative judges? What are the conditions for an administrative decision to be annulled? There are various grounds. The first ground is the lack of competence of the author of the decision, which means that the author had not the legal power to take this decision, or the decision was taken by an incompetent body. The decision, the second ground is if the decision is vitiated by a formal flaw or procedural irregularity. I will give two examples. An adverse individual decision, like a disciplinary sanction, must always be motivated. It should be reasoned. And if it's not motivated, it would be annulled by the administrative judge. Also, for instance, certain decisions authorizing a large building or authorizing building a factory should only be taken after consulting the technical authorities. Otherwise, they would be annulled by the administrative judge. And the last ground are in case the decision rests on an error of fact or an error of law. What means that? For an example of an error of fact, it's easy to understand. For example, if a disciplinary sanction for a civil servant was based on facts which are not fully established. So in this case, the disciplinary sanction would be rescinded. And if the disciplinary sanction has not been listed in the statute governing this category of civil servant, it will be rescinded, but in this case, it would be an error of law and not an error of fact. Now, I am coming to the most important slide of this presentation, which is the French hierarchy of legal norm. So you see the hierarchy of legal norm in this slide, but at the bottom, what is not written is, of course, the individual decision, which are not legal norms, but legal individual decision, which are necessarily taken to be lawful in compliance with all the standards which are above in the hierarchy of legal norm. So, in fact, the notion of rule of laws implies simply that the administration is required to respect the principle of legality, which means that its decision, any decision taken by any administration, must be articulated according to standards superior, respecting this legal hierarchy of norms. In this legal hierarchy of norms, what is central is here the statute, if you prefer, the parliamentary acts, what we call the loi. What is the statutory law? It refers to the acts passed by legislature, the lawmaker being, in a democracy, elected by the citizen. They can be called Congress or Parliament. They can be made by a House of Representatives and a Senate. In some states, they can also be adopted by referendum, but the legitimacy of these statutes are generally, the legitimacy is generally recognized in democracy. Below the statutes are the regulation made by the executive power under the authority of this statutory act. The executive power being generally for the state, the government, prime minister, ministers, and the delegated authorities, representing the government in region or boroughs, counties, cities. These delegated authorities are called in France prefect and deputy prefects. But there are also the local authorities, the regions, the cities, which have their own representative bodies, regional or borough councils, city councils, mayors, who can make administrative regulation and individual decision as long as those decisions comply with the law, which means that they do not violate any of the standards which are above in this hierarchy of legal norm. And so, as I mentioned, all individual administrative decisions can be issued only on the ground of a legal regulation. But the statutory acts, now I am broaching the most important issue. The statutory acts, which are here in the hierarchy of norms, themselves must abide by law which prevail on them. This is relatively recent. Our current constitution, which is on the top of the hierarchy of legal norm, was adopted in 1958 and was amended 24 times since then. But it's the Constitutional Court which had the competence to check the compliance of the statute toward the Constitution, and generally it was done before the law was promulgated. These acts of parliament were promulgated. But the condition under which the Constitutional Council, which is our Constitutional Court, is called Constitutional Council, can besides have also been extremely extended during the last 40 years, which makes that the statutes are not as important as they were before because they can be annulled by the Constitutional Council. But more important are the treaties now, because the treaties under our Constitution prevail on statutory acts. More precisely, the Article 55 of our Constitution states, treaties or agreement duly ratified or approved shall, upon publication, prevail over acts of Parliament, subject with respect to each agreement or treaty to its application by the other party. So as you see, this shows that in 1958, when the Constitution was adopted, they only refer to bilateral treaties, which was, it was only bilateral treaties which were taken into account. There were at this time very few multilateral treaties, and even fewer multilateral treaties empowering outside bodies outside France, to pass new laws and submit France to international court. But since 1958, not only has France signed multiple multilateral treaties, the implementation of which is not subject to their application by other parties, but more importantly, two of these multilateral treaties have had a dramatic effect on the whole of French law, not only by the wording, but by the very broad interpretation of these treaties given by the international courts established by these treaties. I am referring especially to two treaties which are the most important in defining French law now. The treaty establishing the Council of Europe with the European Convention of Human Rights, which was established as soon as 1948, but at this time it has not the effect that it has now. And the treaty establishing the European Community, which was signed from 1967, but at the beginning, the court they established had little power, and their power were extended significantly during the last 50 years, and also when the European Community became the European Union. I will try to explain the consequences on the role of administrative judges, and more generally on the role of judges and the type of political crisis that this development has generated. But let's first insist on the success of the administrative judges. As you can see, the number of cases judged by administrative justice show progress in the rule of law. It's not necessary to mention all this number, but just I would like to underline that administrative litigation has increased by 80% in the last 20 years. This increase of the number of administrative litigation is partly due to the development of public action, the multiplication of administrative decisions like social. We have a very good welfare state in France, which means that there are a lot of decisions for social regulation on social assistance, public subsidies for the unemployed, for people with disabilities, for housing, which creates thousands of disputes brought by people who hope to be eligible for these aids or subsidies, but are not always eligible. But the main reason for the surge in the number of cases in recent years is due to immigration litigation, which currently represents nearly 40% of administrative litigation. Another cause of this increase is a generous system of legal aid. Almost 25% of applicants are granted legal aid. So this undoubtedly shows remarkable progress in the rule of law. But this does not mean that it's paradise. There are also, however, administrative judges and more generally judges have come up against criticism in recent years. This criticism can be summarized in 3 points. In addition, the first point is the following. In addition to its role as the Supreme Administrative Court, the Conseil d'État, the Council of State, so the Supreme Administrative Court, which counts 300 members, has also an advisory role to the government for the elaboration of most government bills and ordinances. Although the opinion of the Council of State are not binding in theory, they are, to a large extent, followed by the government in practice. So the Council of State advises the government through 5 specialized departments. And certainly for the government, obtaining the opinion of the most eminent lawyers in France is important to improve the legal quality of these bills and ordinances. Although the 2 rules of the Council of State, advising and judging, are theoretically separated, there is not a Chinese wall between these 2 functions. The members are appointed to serve in the litigation department and or in an advisory department. But members who advise and people who judge are members of the same institution. They live together, they came from the same high-level administrative court, ENA, École Nationale d'Administration, and even the presidents of the 5 specialized departments can participate to the judgment of the most important cases. Therefore, this creates the suspicion that, as a judge of the state, the Conseil d'État, the Council of State, would not be as neutral as it should be. It is sometimes difficult to separate totally the legal role from a political role. So this is the first point. The second point is that it's this suspicion of incestuous relationship with the government from the Conseil d'État, the Council of State, with the government, is aggravated by the fact that many members of the Council of State choose to work outside the Council of State after a few years, for example, by assisting the President of the Republic, the Prime Minister, or other members of the cabinet. They may also be seconded to key posts in the French administration. They keep personal links with their colleagues, which stay in the litigation department of the Conseil d'État, which may influence them when they have to judge the legality of an executive order or of a decree. The last criticism is related to what some people call the government of judges. As it was mentioned by Mr. Dean, we are in a civil law system, and I should recall the Article 3 of our Constitution, which states national sovereignty shall vest in the people who shall exercise it through their representative and by means of referendum. A democracy is based on the separation of powers, legislative power, executive power, and judicial. The role of the latter being to judge individual cases by applying the law passed by the legislature, and not to create the law, at least in our system. But the sources of law are now not only national, especially in Europe. An important part of the law in European countries come from not only from the treaties, but from what we call secondary European Union law. That is to say, the regulations and directives adopted by the institution of the European Union through a complex procedure difficult to understand by ordinary citizens. And since the treaties, as I mentioned, prevail on statutory acts, the French judges have considered that even secondary European Union law prevail on French statutory acts, including subsequent statutory acts. And they follow, the administrative judge, and follow the interpretation of the Court of Justice of European Union on the interpretation of this secondary law. So at first, ordinary citizens did not understand the consequences of these legal complexities. But eventually, they realized that France is, in relation to the European Union, in a situation close to that of a state government integrated into a federal state. And this created a kind of nationalist backlash in France, like in many countries of the European Union, including, in fact, the United Kingdom. This is the main reason why there was a Brexit. In addition to the European Union law, there were the interpretations of the European Convention of Human Rights made by the European Court of Human Rights, which was so liberal that it led to paralyze the implementation of many statutory law, especially in countries like France, in which the administrative judges adopted this interpretation given by the jurisprudence of European Court of Human Rights as law prevailing on the statute. So you can see that European European Convention of Human Rights had been signed by more than 40 countries, but all these countries does not follow the jurisprudence of the European Court of Human Rights as France do, and especially this jurisprudence does not prevail on the statute. For us, it prevails on the statute. So by paralyzing sometimes statutory law because they do not comply with the jurisprudence of international courts, like the Court of Justice of the European Community, of the European Union, and the European Court of Human Rights, judges are sometimes seen as imposing their own governments when they lack the legitimacy granted by the citizens. And if the judges are not careful to use this power with moderation, they may suffer a backlash coming from the feeling that the people, the citizens, cannot control who governs them. This current situation of tensions in liberal democracies between the democratic aspects, the government by the people, and the liberal aspect, the rule of law, has been analyzed by many political scientists who have seen the emergence of what is called now illiberal democracies. Some of these illiberal democracies have restricted the power of the judges with the support of the citizens who elected the government precisely because the people did no longer understand who creates the law. These tensions are not easy to face. It's necessary to maintain a reasonable balance between these two aspects. Lawyers and judges in all countries must bear in mind this contradiction and their responsibility to apply the law without exceeding their power. Thank you. Thank you for your attention. And I would be very interested in hearing from you if we have time.
Thank you so much, ma'am, for your eye-opening insights. They have indeed been very enlightening for all of us. I would now like to put forth the questions before ma'am that we have received from our participants during the session. The first question we have is, what was the main object behind designating separate courts to deal with administrative acts in France? And can administrative matters come before the normal judicial courts?
In fact, this is an historical reason. Precisely at the time, at the French Revolution, at the end of the 18th century, it was considered that the court were precisely blocking some reforms which were wanted by the then government. And that's why it was forbidden for the judiciary court, I mean, which were the only court which existed at this time, to issue any kind of regulation or any kind of general rules. And then after a few years after, I can't go to the details, the Council of State was created only as an advisory body. And then this advisory body decided to judge the administrative decision, although at the beginning it was supposed only to advise the state on if they consider that their decision was unlawful, but they were not supposed to annul it. Then they decided during the 19th century, at the end of the 19th century, to annul some decision, and then after there were the first administrative courts, first level administrative court were created in 1954, and the Administrative Court of Appeal in 1987. So it's linked with the French history.
Okay, ma'am. The next question that we have is, what has particularly affected the ideologies and foundations of French Constitution in light of separation of power in case of administrative courts?
The basis of, I mean, in fact, in our constitution, because of this history, there was a kind of distrust towards the judges, you know. But it's only the judiciary court which are expressly mentioned in the constitution. But our constitutional councils interpreting our constitution considered that the administrative courts now have constitutional recognition. But it's true that it was really the Council of State, the Conseil d'État, which took more and more influence, developing the rule of law, which is, of course, something that everyone should be very happy that it exists. But with the nationalist backlash now, especially toward law coming from the European Union and even more from the interpretation of the European Court of Human Rights. In fact, the Brexit was also in United Kingdom. If you follow very, very thoroughly what happened with the Brexit, you could see that people were, the citizens who voted for Brexit, sometimes they did not really understand the difference between the European Union law and the European Convention of Human Rights, although they are totally different institutions. So that's a backlash we are seeing now, but I think that we are seeing it in many countries.
Okay, ma'am. The next question that we have is, can the judicial courts act as courts of first instance in case of challenge to executive action? Yes.
For any, the court of, what we call the administrative tribunal, like the one I presided in Lille, but there are, as I mentioned, many other, this administrative court can annul any executive decision just directly, but for the decrees, which mean the executive orders which are taken by the government directly, these can be annulled only by the Conseil d'État. It's a little difficult to go to the detail, but for instance, a regulation issued by a mayor, like urban zoning city, urban zoning regulation in a city, or a local regulation can be annulled by the first level trial court.
The last question that I have, ma'am, is, are the criticisms of administrative court system so grave that, in your learned opinion, it warrants some sort of reform?
I think that the system is so complex that the main problem from my point of view is that most citizens don't understand, so you are young lawyers and you realize how complicated it is to learn law and to understand it. So I don't think that the citizens are really proposing some reform of the administrative system. But what some of them feel is that the law is too complicated and that they can't control it even by voting for their representatives, because a part of the law comes from the European level and prevail over the statutes which are passed by the representative. And this is a very important debate for the moment in France, especially because of the terrorism. As you may know, we had hundreds of attacks of terrorism during the last 5 years, and there were hundreds of people who died, and many citizens don't understand that some migrants who may become terrorists had been protected by the law, and especially, for instance, when they have family in France. So I will try to give an example. Article 8 of the European of the European Convention of Human Rights defend the right to have a private life and a family life. But this family life has been interpreted in a way by the European Court of Human Rights which prevail on public order. So the result being that some people, because they just have a relationship with a French woman, even if they are not married, they can get sometimes a permit to stay, and they can be protected against expulsion. And this is very difficult to understand for the ordinary citizen. So it's not promoting a reform, but trying to understand the hierarchy of norms. That's why I focused on the hierarchy of norm.
Thank you so much, ma'am, for clearing all the doubts of our participants. I would like to bring it to everyone's notice that the link to the whole lecture will be available on the YouTube channel of Uttaranchal University. I would now like to request Mr. Mohammad Danish Khan, Vice President, Moot Court Society, to please deliver the vote of thanks.
Thank you, Aditi. Good afternoon, everyone. On behalf of the Moot Court Society, I, Mohammad Danish Khan, Vice President, Moot Court Society, am honored to present vote of thanks on this occasion. Firstly, I would like to thank Judge Joëlle Adda, who agreed to lead this online lecture as a keynote speaker. It's an honor to get to know about the topic from an avid scholar like you. Thank you, ma'am, for imparting us such wide knowledge. Next, I would like to thank Professor Dr. Rajesh Pagoda and Poonam Rawat, ma'am, a patron and chairperson respectively, who constantly supported and encouraged us every time in organizing a productive event that will promote legal learning. Thank you, ma'am and sir. Lastly, I would like to thank all the participants for registering and attending the seminar and made this experience richer. Thank you, everyone.
Thank you again.